All rise. The Lawyer of the Apes is now in session. Hey guys, how's it going? Welcome to episode 4 of Lawyer of the Apes. Today we're going to be talking about the short squeeze antitrust motion to dismiss and the opposition papers. The reply papers have not been uploaded yet, but they should be up within the next couple of days, and then I'll go over the reply. The reply papers really won't add anything new. It'll basically be a little bit of a reiteration of the motion to dismiss and also address some of the factors set forth in the opposition. At that time, the defendant is not permitted to raise any new issues without court permission, and they haven't asked for that, so they shouldn't be raising any new issues. If they do, they may give the plaintiff an opportunity to submit what's called a SIR reply, but that is also only given by the court's permission. So we will probably not get that. We'll probably just get the motion, the opposition, and the reply, and then it'll all be submitted, and then we'll have to wait for 60 days for the decision. Just so a quick overview. So remember, guys, there were 2 complaints that were filed. One complaint is for antitrust violation of the Sherman Act, and the second one is against Robinhood for a variety of other things, such as negligence and breach of fiduciary duty. So there are no papers in on the motion to dismiss for the Robinhood case yet. However, we do have, like I said, on the antitrust part, we do have the motion and the opposition. So let's go. We're going to go through the motion to dismiss and the opposition today. I posted them both on my Twitter feed, so you can print them out and go along with it while you are listening, or I'll be showing it on the screen as well. Before we get into the actual motions themselves, though, I just want to give you a little background. So, like I said, the complaint is based upon a violation of the Sherman Act. So what is the Sherman Act? Let's take a look at that for a second. Okay, so the Sherman Antitrust Act of 1890 is a federal statute which prohibits activities that restrict interstate commerce and competition in the marketplace. The Sherman Act was amended by the Clayton Act in 1914. The Sherman Act is codified in 15 U.S.C. sections 1 through 38. So basically, the section 1 of the Sherman Act, which is what is set forth as being violated in the complaint, says that every contract, combination in the form of trust or otherwise, or conspiracy and restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. So basically, guys, in a nutshell, it basically says that you as an individual cannot conspire or do on your own the restraint of trade. So basically, that's what the plaintiffs are alleging in this case. They're saying that Robinhood, Citadel, and a bunch of other corporations and market makers all conspired together to restrain trade, to limit the retail investors' ability to trade. So that's basically what the crux of the elements are in regards to the complaint. Now, if you take a look at the cases that we're going to be looking at, the motion, this is what the motion looks like. This is the first page of the motion to dismiss. It says defendant's motion to dismiss and memorandum of law. So we go through it. All motions are standard. They have a table of contents, and then they have what's called a table of authorities. The authorities are all of the cases that they're going to be relying upon in their motion to support the reason why they believe that the case should be dismissed. Most of the cases are federal court cases or Supreme Court cases. And the reason why I'm mentioning this is because one of the most important cases that is cited to in both the motion to dismiss and the opposition papers is a case that is called Bell Atlantic versus Twombly. Now, why is that case important? It's one of the most important cases because it really modified the idea of what's necessary in order to establish a pleading when it comes to a violation of the Sherman Act. So what happened in Twombly? So 2 guys, William Twombly and Lawrence Marcus, they brought a class action lawsuit alleging that Bell Atlantic and Baby Bells, they engaged in anti-competitive behavior in violation of Section 1 of the Sherman Antitrust Act. They said that the companies acted to disadvantage smaller telephone companies and charge consumers more by refraining from entering markets where other large companies were dominant, thereby providing and preventing price wars. Even though the Telecommunication Act of '96 made it relatively inexpensive to do so, they still allege that. The lawsuit alleged a conspiracy between the Baby Bells not to compete with one another. For example, the lawsuit pointed out that Quest did not compete in California despite having business in the surrounding states. and Verizon did no business in Connecticut, besides the fact that they had a monopoly in all the surrounding states. So this court was heard before the U.S. District Court of the Southern District of New York. That's the lowest court possible in New York to hear this type of case. And the complaint was dismissed pursuant to Rule 12b-6, which is the same exact rule that is being addressed in the motion that is before the judge now. That was appealed. The court, the second level of court, the Second Circuit Court of Appeals, they heard the case and they reversed it. They said, no, we believe, based upon the pleadings, there is sufficient evidence demonstrating the existence of a violation of the Sherman Act. Therefore, the case can go forward. Then, guess what? In that case, the defendant appealed, saying, no, you're wrong. So where's the next place you go after the Second Circuit? All the way up to the top, to the big boys and girls at the Supreme Court. So in 2006, the court agreed to hear the case of Twombly versus Bell Atlantic versus Twombly. So what happened then? Well, the bad news is the court reversed the decision of the Second Circuit and said that the plaintiffs failed to prove that there was enough allegations to show a violation of the Sherman Act to allow the case to go forward. So basically what they did was the court clarified the requirements of what you have of providing a claim for anti-competitive behavior under Section 1 of the Sherman Act. So like I said before, the Sherman Act prohibits entering into a contract, combination, or conspiracy to restrain trade. Remember, you cannot conspire to restrain trade. And that is the allegation that Citadel, Robinhood, many others conspire to restrain the trade of the retail investor. The court held that while parallel conduct, which is actions by competing companies, is admissible circumstantial evidence from which an agreement to engage in anti-competitive behavior may be inferred, parallel conduct alone is insufficient to prove a Sherman Act claim. So remember, that's important to remember in this. In that case, they only had circumstantial evidence of parallel conduct. And I'll show you in the motions why that's important, because there's other ways that you can prove a case under the Sherman Act. But in this case, they said that if they're relying solely upon parallel conduct, you cannot just have circumstantial evidence. So basically, the court said that they didn't show there was enough facts to find plausibility that the companies had engaged in a conspiracy. Instead, the complaint provided factual basis for parallel conduct, not enough in the court's view to violate the Sherman Act, and stated that only an agreement had taken place, that no details supported the allegation. So there was an agreement, but there wasn't any proof that it actually led to an actual conspiracy. So therefore, the court dismissed the complaint as being improper. Now, this was an important decision back in 2006 because it changed the interpretation of the pleading requirement under the Federal Rules of Procedure, Section 8, and also 12b-6 by making a stricter standard for pleading. Previously, it was a little bit easier. Instead of it having to be a plausible standard, it only had to be a conceivable standard. So the difference is was a little bit easier at the time for the plaintiffs to establish, and probably under the conceivability standard, they might have been able to pass the muster. But at that time, the court decided to shift and make it more challenging for plaintiffs to be able to establish their case. So basically, the court said two working principles underlie our decision in Twombly. First, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. Second, only a complaint that states a plausible claim for relief survives a motion to dismiss. So again, keep all of that in mind while I'm going through the motion to dismiss and the opposition papers. So it's true. The court has to consider all of the allegations in the complaint to be true, but they cannot lead to the legal conclusions. And the allegations have to be plausible, not just conceivable. So that's something to consider while we're looking through the papers. So like I said, so you have the cases that they're going to rely on, the statutes and the rules that they're going to rely upon, other various authorities like SEC reports. Okay, so here we go. Here's the motion to dismiss. Let's dive right into it now that we have that background. So basically, this is what's called the preliminary statement. This is where they set forth the facts that they want the judge to see. This is their version of the facts. This is them saying yes, we know everything they said in their papers, but this is how we see it. This is what really happens. Wink, wink. So anyway, I only highlighted. There's a lot in here, but like I said, I'm only going to highlight the important parts and go over them. So the defendants come out lamenting right away that for unprecedented market volatility impacted brokerages in different ways and led market participants to make different actions in an effort to address the impact of volatility. Now you're going to find this theme throughout the motion to dismiss. The idea that all the brokerages acted in different ways, because their argument is, listen, you guys are saying that we conspired against the retail trader. If we did that, wouldn't we all have done the same thing? Wouldn't we have directed everybody to do the same exact thing? Doesn't that make sense? Well, that's what they want the court to believe. So basically they're saying, and they say it in this next paragraph, each brokerage firm responded to these market developments differently. One of the defendants in this case, here we go, defendant Citadel Securities continued to facilitate the trading activity from its retail brokerage clients during the relevant time period without interruption or restriction every minute of January 28, 2021. Well, of course, listen, that wasn't the conspiracy. The conspiracy was allegedly to get Robinhood to, put the restrictions in place and many other brokerages. So this is kind of a smoke and mirrors. We're like, oh, we're the good guys. Citadel, we're Citadel. We weren't doing anything bad. We were still business as usual, guys. We were doing everything right. Nothing to see here. They go on. The antitrust claim is predicated on the speculative contention that the meme stock prices. It's so offensive, meme stock. It's ridiculous. It still drives me crazy that they have to call it that. Anyway, whatever. I digress. The antitrust claim is predicated on the speculative contention that the meme stock prices would have been even higher but for the alleged conduct, combined with the absurd contention that every member of the class was harmed because they would somehow have timed the market perfectly, absent the restrictions, and sold their shares of the meme stocks at profit. So basically what they're saying is this. They're saying, hey, listen, even if what you're saying is true, there's no way that you guys can prove damages. There's no way you can show that you would have sold the stock when and if it was going to hit $500. So there's your claim for damages is completely speculative. Of course it's completely speculative. No kidding. It's because you guys conspired to restrict trade, so nobody will have any idea. It's ridiculous. Of course it's speculative, and there's nothing wrong with it being speculative. This is the pleading stage. Of course everything is going to be speculative. We can bring in forensic accountants. You can bring in people that can be experts and say what they may have believed they could have reached in terms of price based upon prior market history. So that's nonsense that they're saying it's speculative in nature. Okay, that has nothing to do with the pleading stage. Let's get past the pleading stage. Let's throw some people on the stand. Let's get some experts involved, and let's see where this thing would have gone. So that's completely ridiculous, and I don't believe that holds any water. They say that there's no evidence of an actual agreement. Again, remember, this is the pleading stage. They don't need actual is not the word you need. You do not need actual evidence. You need plausible evidence. Plausible evidence is what you need. Again, they go through Twombly, which of course I said they would, because that is the leading case and what you need to do to show a conspiracy. So they say, according to plaintiffs, the real reason the introducing brokers introduced desperate restrictions was because Citadel Securities, alleged to have a commercial relationship with some, but not all of the defendants, sought to depress the price of the relevant securities to protect Citadel's alleged short position. Correct. That is what plaintiff's position is. Very well stated. I agree with that. The circumstances alleged here are a far cry from an actual antitrust conspiracy, where the challenged conduct is unprofitable for any individual firm to engage in alone, but becomes profitable when pursued as a group. Instead, the restrictions cost each broker revenue because they reduce trading volume, regardless of how many other brokers also limited trading, and any one broker's ability to implement restrictions did not depend on the others doing the same thing. There is no plausible explanation for why, plausible, there's that word, for why various broker defendants would have sacrificed their own financial interests to help Citadel and protect it against alleged short position for which plaintiffs concede they lack an actual evidence. Hello, are you trying to pull the wool over our eyes? Do you think we're stupid? Do you not realize that we know that Citadel pays Robinhood millions of dollars for payment for order flow? So to say that they have no financial interest to lose by not covering Citadel's butt is absolutely preposterous. But again, that's just an allegation, So anyway, let's keep going. Plaintiff's claim also suffers from two other independent fatal defects. First, even if plaintiff had plausibly pled an agreement among the defendants, which they have not, they're claiming, they still have not pleaded any of the remaining elements of Section 1, which we'll get into. Second, this case is no more than a securities complaint in antitrust clothing. So that's an interesting aspect of this case that I think we'll talk about right now, and even though we get into it in more detail. So basically, they're saying that this is not truly an antitrust action. This is a securities complaint. And therefore, this is not the proper venue, and the case should be dismissed because it should be handled by the SEC. And this is not really antitrust. This is actually a securities issue. And since it's a securities issue, that's up to the securities to people to decide. That's up to the SEC to handle. This does not belong in court. I don't believe that to be true, but that is the argument that they're making. They're making this being a securities issue. Now, let's be honest for a second here, guys. In order for it to be a securities issue, the SEC actually has to be doing something. Now, I know they're saying that they're conducting an investigation, but exactly what are they investigating? Are they actually investigating what the allegations are in this? And if they are investigating that, why aren't there any handcuffs on anybody yet? So I'm not sure that this argument is going to hold much water because I really don't think the SEC, as of right now, is doing much of anything. But we'll see what happens. I mean, that may come into play one day. I mean, it's possible. So, all right, so let's go on and see what they say here. The skyrocketing and epic price surge in the relevant securities were unrelated to factors that the securities industry participants traditionally expect would affect stock prices. In the span of just 5 trading days, the total daily trading volume for the relevant securities increased from 230 million to 3.3 billion. By the end of that 3-day period, the SEC released a statement warning of ongoing market volatility in the options and equities market. I remember this all like it was yesterday. It's pretty wild. On the morning of January 28th, I remember waking up, sitting in bed, looking on my iPhone. The NSCC also issued significant increased collateral calls for different brokers. For example, the NSCC increased Robinhood Securities deposits requirements to over $3 billion. Oh, boo-hoo for Robinhood. After several hours of internal deliberation and in light of the major liquidity issues created by the capital call, it made the difficult decision to impose I love this flowery language, what a joke. To impose temporary trading restrictions on the limited number of securities driving the volatility. Robinhood Securities put in place a position closing only restriction on the stock trades and option contracts for AMC, BlackBerry, Bed Bath & Beyond, Express, GME, COS, Nokia, and a couple of other tickers. So basically, I'm not going to, relive this moment. We all know what happens here. We know that they, took away our rights at this moment on that date. The remaining broker defendants also imposed a variety of different restrictions, each taking its own approach given the unique issues and considerations that each faced during the period. So again, they keep reiterating this idea that listen, Robinhood did this, E-Trade did that, and everybody did different things. So again, how can we have all conspired to hurt retail if everybody went their own way? We'll see why. Plaintiffs do not allege that all of the defendants met or otherwise coordinated these restrictions. Again, you don't have to meet. That's not a requirement. There's no requirement that you met. You could talk, you could text, you could call, you can have clandestine conversations. You just have to prove that they're plausible. But again, you don't have to meet anybody in order for there to be a conspiracy. Okay, so basically now we're going to get into the meat and potatoes of the argument, the legal argument. Pleading a violation of Section 1 of the Sherman Act requires 1, a conspiracy, that 2, unreasonably, 3, restrains interstate or foreign trade. Again, we already know what that means. That these parties conspired. That means they all got together and talked in some way or communicated in some way in an unreasonable manner because they weren't thinking. Well, they were thinking, but they were thinking with their pockets to try to screw retail, and with an attempt to restrain trade. So basically, that's it. In considering a motion to dismiss a case brought under Section 1 of the Sherman Act, the court must determine whether the complaint in asserting a conspiracy or agreement in restraint of trade contains allegations plausibly suggesting. Plausibly, there's the word again. Remember, plausibly. And remember, that used to be conceivable, but now because of Twombly, Supreme Court made it harder for plaintiffs, of course, not merely consistent with conspiracy agreement. That is, whether the complaint possesses enough heft to show that the pleader is entitled to relief. Plausibility is the key, as the well-pled allegations must nudge the claim across the line from conceivable to plausible. There we go. I mean, that's it again, guys. Just like I said when we started this video, the goalpost was moved, not on retail traders, but just on plaintiffs in general. Whenever they want to file an action for conspiracy under the Sherman Act, they move the goalposts on us further by changing it from conceivable to plausible. The crucial question with regard to a conspiracy claim under Section 1 is whether the challenged anti-competitive conduct stems from independent decision or from an agreement. Plaintiff must present direct or circumstantial evidence that reasonably tends to prove that the defendant and others had conscious commitment to a common scheme designated to achieve an unlawful objective. So here we go. This is what I was talking about before. Remember, in the Twombly case, there was only circumstantial evidence, remember. So because there was only circumstantial evidence, the plaintiffs had to show parallel conduct, which is here, and plus factors, and a common move to conspire. So basically, again, direct or circumstantial. So the question before the court and in this motion will be for them to show that the pleading does not show any direct communication. Now, again, these are all allegations in the complaint, but if you looked at this, I'm pretty sure we all looked at the same complaint together, and there were some pretty direct communications between Citadel, Robinhood, and a few other parties. So I know that the lawyers in this motion are using flowery language to get the judge to believe their side of the case, and they're going to say no, there was no direct communication. That wasn't direct. It was all circumstantial. We'll have to see how the judge falls on that. But let's get going. If the alleged conduct is not anti-competitive per se, the rule of reason analysis requires plaintiff to prove an anti-competitive effect of the defendant's conduct on the relevant market. And this is even more interesting, conduct in the relevant market. They actually say in this motion later on that the plaintiff hasn't shown that there's an actual relevant market that's being manipulated, which is completely out the window. I don't understand how they can even make that argument. But I mean, look, lawyers get paid, so they have to make, as many arguments as they can. Some of them are plausible and some of them are not. And two, that the conduct has no pro-competitive benefit or justification. Then plaintiffs must show either actual anti-competitive harm in that market, which include a reduction of output, increase in price, or deterioration of quality. I mean, basically just reading those elements in and of themselves, that basically sums up pretty succinctly exactly what happened in this case. So I'm really not sure what they're trying here. A potential harm, which requires plaintiffs also to show the defendants possess power in the market. Now, I know that's their big thing. They're saying later on in this motion that there's no way that Citadel has enough power in the market to move the markets or move people to do things. But again, they're ignoring the big elephant in the room, payment for order flow, and the money involved. Plaintiffs' claim fail for three independent reasons under these standards. First, plaintiffs failed to plead any allegation sufficient to support an inference of an agreement. And there's a law perfectly, guys, I know you're saying what we did was illegal, but hold on, we can explain. That's exactly what they're doing here. They're doing the old, oh yeah, sorry officer, yeah, it's a perfectly reasonable explanation for why I have my hand in the cookie jar. Second, plaintiffs failed to allege the necessary elements, and then, of course, like I said before, they're claiming that this is precluded because it should be controlling under the federal securities laws, not an antitrust action. Plaintiffs allege that entities at three different levels of the financial industry, Citadel Securities is the market maker, the clearing broker defendants, and the introducing broker defendants, all conspired in the span of a few days to impose different trading limitations on different stocks. It's funny, they are writing that, and they're basically writing that and saying, how can anyone possibly believe that's true? I mean, how can you not believe that it's true? It doesn't take that much for a group of individuals to get together and to concoct an idea like this. People have come up with even more complex ideas than this in an even shorter period of time. So this whole idea that, oh, this was done so quickly, it's not even reasonable to think that it was possible. That's a little, out there. But plaintiffs do not specify in any way what the alleged agreement was. Yes, they did. That is pretty clearly set forth in the pleading. So I'm not sure what that means. It contours or even the structure of an alleged conspiracy. again, sometimes I feel like I didn't read the same complaint that these guys did. Plaintiffs had the opportunity to review more than 25,000 pages of documents that defendants produced to government regulators and then reproduced to plaintiffs. Then they even requested a 14-day extension of their deadline to file the instant complaint to allow more time to review those materials. I mean, of course they asked for a 14-day extension. They had to review 25,000 pages. That's ridiculous. Of course they needed more time to do that. Why would you want to rush that? Well, of course they would want them to rush that because here's what happens. This is the practical aspect of it all. All right. There's 25,000 pages of documents, and somewhere at page 20,000, they slip in that one document that shows the smoking gun or the potential smoking gun with the hopes that, guess what? Well, we'll tire them after page 20, and then they're not going to see this. So that's basically the tactic of all these thousands and thousands of pages of documents. If you were being honest with yourselves and you wanted to submit only the relevant documentation, it would probably be about $5,000 worth of 5,000 pages worth of documents, if that. So again, the whole 25,000 pages, yes, they did submit all that, and that is a tactic. I mean, that's not I don't know that to be fact. I'm just saying that is definitely a tactic that I've heard of in the legal community that is sometimes used. Sometimes, sharp practice, we would call that. Plaintiffs have provided no direct evidence of an agreement, no direct evidence concerning when, where, or how the alleged conspiracy was entered, or who was a part of it, or what its structure or purpose was. Yes, we did. We pretty much saw clearly that there was conversations between high-level executives at Robinhood and Citadel, as alleged. The court may infer from the factual allegations in the complaint of obvious alternative explanations, which suggest lawful conduct rather than the unlawful conduct that the plaintiff would ask the court to infer. So here they're saying again, listen, we have a logical explanation for this, guys. This wasn't done for nefarious reasons. This was done because of a real bad situation that came upon us, and we had no choice. For example, according to plaintiff's own allegations, Robinhood faced a deficit of more than $3 billion on January 28th as a result of the NSCC's collateral call. Here we go. Now we're getting into we can explain, officer. These pleaded facts are not, as plaintiff asserts, simply cover for an alleged conspiracy. They provide a plausible and actual non-conspiratorial explanation of the broker's independent responses to common stimuli unaided by an advanced understanding among the parties. So basically, this language that they're citing from Twombly, independent response to common stimuli unaided by an advanced understanding among the parties. So they're basically saying, listen, there was an outside incident, and because of that incident, we had to do what we did. It had nothing to do with the fact that we were trying to screw retail. Plaintiff concedes that a significant number of brokers that are not alleged to have been conspirators enacted trading restrictions in response to the market volatility and volume. Yes, that's true. They didn't. There are brokerages that did do restrictions, but the restrictions were a lot different than completely restricting the ability to purchase shares. So there's a big difference there. So I'm not really sure that there's a lot to hang their hat on, but they're trying. Second, the alleged parallel conduct by the defendant varied in material ways, both before and after NSC collateral calls on January 28th. Again, they're saying the whole thing, how the conduct was all disparate between the different trading brokerages. So here's the table that they show. The table below summarizes plaintiff's allegations concerning the trading restrictions implemented by various brokers, both alleged conspirators and non-conspirators. Plaintiff must thus concede that the restrictions took different forms. So basically they're saying, again, like what I said, they're saying that these guys, everyone did something different. So TD Ameritrade placed restrictions and increased margin requirements. Schwab placed restrictions. Robinhood disabled margin trading. Robinhood moved option contract to position closing only. Stash, E-Trade, Robinhood, Webull, SoFi, Apex, Ally. So basically you're looking at what one of these things doesn't go with the other, right, guys? I mean, let's take a look. Robinhood moved option contract to position closing only. Again, we're not talking, yes, they all did different things, but some of them did more than others. So they all acted in some type of form, and the allegation is definitely that at least the brokerages that completely halted trading were definitely alleged to have conspired for something. These allegations simply cannot support an inference of conspiracy because defendants' actions were not uniform, and defendants each reacted in different ways, explaining that defendants' conduct was not in fact parallel, where some defendants refused to pay imposed surcharges, while others undertook independent effort to negotiate or agreed to temporarily pay surcharges. So again, guys, we have a situation here where they're claiming that, listen, there couldn't be a conspiracy because everyone did something different. The only way it would make sense for it to be a conspiracy is if everybody did the same thing. Again, that's a question of fact for the judge to decide, but that's not a question of fact for the judge to decide right now. This is a pleading stage. So again, we just need to show that there is a plausible possibility that this stuff happened. And I think these facts definitely are plausible. There's definitely a plausibility standard that's being met here to sufficient to get more discovery to prove the allegations even more. And that's really what we need, what they need. Plaintiffs further failed to plead sufficient plus factors. Such a common motive to conspire would require that the parties had a collective interest in acting in concert to achieve an anti-competitive end. But plaintiff failed to allege any facts to establish that Citadel Securities held short positions in the relevant securities during the relevant time period, sheepishly conceding it is not possible to ascertain which investor had a short position in a particular security at any particular time. That's not wrong. That is actually a true statement. It is impossible to make that determination. However, that is something that could be learned in discovery, and it is plausible because if you guys recall, during the time, the short positions in these securities had gone up exponentially, and then suddenly they went down. So basically, guys, again, we have a situation where they are alleging a fact that is plausibly could be proven with further discovery. Indeed, there is no factual allegation, simply mere innuendo supporting the proposition that Citadel Securities asked, induced, or coerced any of the defendants. Again, situation here, it's not innuendo. There are direct conversations that are being alleged in the complaint. So I'm going back and hanging the hat on the whole thing that there is direct evidence. There's not just circumstantial evidence. Oh, and I gleamed over this question by accident. Why then would various clearing introducing brokers defendants decide they want to lose money and risk negative publicity simply to help Citadel? So again, Robinhood. Yes. Did they have a ton of egg on their face after what they did? Did it cause a ton of negative publicity? And did it cause them to lose money in the short term? Yes. But you can't kill the golden goose. And that's really what we're talking about here. We're talking about a situation and an allegation that if Robinhood didn't help out the golden goose, who else was going to pay for all their payment for order flow? That's the allegation. Plaintiffs entirely failed to allege any actions taken by the defendant against their self-interest that are prohibitive of conspiracy. Again, yes, okay, not directly, but if you think about it, you put your thinking cap on. I'm not talking about a tinfoil hat here, guys. This is not that type of thing. You're not talking about tinfoil conspiracy here. You're talking about logical thinking. Who is lining Robinhood's pockets on a daily basis with the majority of the money for PFOF? It doesn't take a lot to think about it. In other words, this plus factor is present when alleged conspirators do something that would be unprofitable if done individually, but becomes profitable through collective action, such as imposing a price increase. First, the allegation gives rise to a plausible non-conspiratorial reason. The clearing and introducing brokers nonetheless were forced out of necessity-imposed restrictions, even though such restrictions create real risk with immediate and long-term reputational and financial harm. Okay, so here we go. We're hands in the cookie jar. Listen, but I can explain. I was walking by the cookie jar and my hand just accidentally fell into it. And here they're saying, or no, better yet, I had to stick my hand in the cookie jar because I saw a bug and I had to squash it because I didn't want it to spoil the cookie. Basically, they're saying, I had no choice in the matter. Our backs were up against the wall. We did this because we had no choice. We didn't want to. It really made us look bad. We're sorry, but that's the only reason why we did it. There's a plausible explanation for it. Second, although restrictions cost each broker revenue, fewer trades mean fewer payment for order flow. Yes, in the short term. But remember, guys, we're talking about, let's think about long term here. If Citadel goes belly up, who's paying the hood? Indeed, there are no allegations that defendant Pete interactive brokers ever spoke or otherwise communicated during the relevant time with each other. Again, wrong, wrong, wrong. Look at the complaint, look at it in more detail, and I think you will be surprised at what you see. Plaintiffs alleged that each alluded to the need to protect his respective company by restricting trading in the relevant securities and implausibly suggest the statements evidence the alleged agreement. In fact, they do the opposite, confirming that each broker had an independent incentive to take action to protect its own business and customers in a time of unprecedented market volatility. Again, they're going back and saying that this had nothing to do with doing something bad, but just listen, this was a bad time. We were at the wrong place at the wrong time. You know, we had this whole new company we started where we're allowing retail investors to trade for free. We're getting paid through PFOF, and then this happened and we weren't ready for it and we screwed up, and that's why we had to do it. It had nothing to do with the fact that we were trying to, save our overlords. Plaintiff alleged that a conspiracy can be inferred based on the announcement of the regulatory investigation stemming from the events of January 2021. Now, this is a double-edged sword, right? Because if you think about it, they're making two arguments. They're saying, and the plaintiffs are saying, well, there was a regulatory announcement that, there's an investigation stemming from the events that took place in January. But now the defendant is arguing, well, if that's true, then this is probably within the purview of the SEC. And if this is in the purview of the SEC, then this antitrust claim is probably not legit and probably shouldn't be here. And this is probably an SEC matter. So, this argument, I don't think I would really hang my hat on this argument. If I was the plaintiff, I would sort of back away from this. I really don't think you need it. Again, it just creates an inference of a conspiracy, and I don't think an inference of a conspiracy is going to be enough to get me Twombly anyway. So I don't know if this is really the best argument, but I'm not the lawyer on the case. I don't like to second guess lawyers, but that's just my 2 cents on it. Even if plaintiffs had adequately alleged an agreement, and they still have not adequately pleaded their antitrust claim, because the complaint fails to define the relevant market, adequately allege market power, and plead anti-competitive effects. Plaintiffs do not even try to allege the requisite elements of a rule of reason claim, instead asserting in a single cursory allegation without any explanation that the purported conspiracy is unlawful per se. So basically, again, they're not trying, plaintiffs are really not trying to argue this. They really are relying upon direct evidence, and they are arguing that what was done is per se treatment. In fact, courts consider conduct to be per se unlawful only when history and analysis have shown that in sufficiently similar circumstances, application of the rule of reason unequivocally results in finding of liability. Per se treatment is therefore typically limited to certain horizontal restraints, restraints imposed by agreement between competitors, whereas vertical restraints imposed by agreement between firms at different levels of distribution are assessed under the rule of reason. Now, after reviewing the complaint, I do believe that this is horizontal restraint. I do not believe that it is vertical restraint. That does not, and we'll get into that when we get into the opposition papers. Thus, what distinguishes this case from price-fixing cases that have been declared per se unlawful is that the alleged horizontal competitors participate in a different market from the market in which the alleged harm was suffered. Per se treatment cannot apply to such alleged agreement where defendants do not profit as market participants from the alleged scheme. Now, this is ridiculous. They're saying that all of these pieces in the puzzle, the market makers, the brokerages, that they're all not part of the same overarching market. They're all their own little separate niche, which is completely preposterous. I mean, come on. Nor is there a per se group boycott case. The group boycott consists of pressuring a party with whom one has a dispute by withholding or enlisting others to withhold patronage or service for the target. Thus, while plaintiffs nod at the concept of either a price conspiracy or group boycott at various points, neither label actually fits at all, never mind in a way that they would sanction application of the per se standard. Blah, 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 flowery language. They really didn't say much, if anything at all, in those paragraphs. Plaintiffs do not actually define the specific contours of any alleged antitrust market, simply alluding instead to numerous markets, including the market for securities, the market for broker-dealers, clearing firms, and market making, the financial markets, and the stock brokerage market with respect to relevant securities. Again, they're saying that this is not a specific market, antitrust market. They're saying that all these things are separate and that this does not equate to being proven under this standard. Nowhere do plaintiffs allege that any defendant possesses market power in any market. Indeed, plaintiffs allege that there were multiple competitors who were not party to the purported conspiracy and still allowed trading in more of the relevant securities. In fact, Burke Minahan, a named plaintiff, alleges that he was able to circumvent Robinhood's purported restrictions by applying for an account with Fidelity and purchasing GME securities throughout that brokerage. Are you serious? This is the exact opposite of what they're trying to say. This shows that Robinhood was up to no good. It shows that what a good, real, legitimate brokerage should have been doing. They should have been allowing traders to trade, not restricting trade. So this actually is a very odd paragraph, and it really goes against their position. Pleading an anti-competitive effect requires plaintiffs to demonstrate actual detrimental effects on competition, such as reduced output, increased prices, or decreased quality in relevant markets. Hello, that's exactly what happened. All the plaintiffs do is plead that the alleged agreement had potential impact on the trading price. Potential impact. There was nothing potential about it. You guys, they halted trading, and supply and demand rules proved one thing. If no one's buying, stock's tanking. A purported harm in purported market in which none of the defendants alleged to compete because they neither produce the relevant securities nor are they alleged to buy or sell them for their own accounts. Plaintiffs failing in this regard are not surprising since this case has nothing to do with competition at all. It has everything to do with competition, everything. Regardless of whether one considers the actual reason for the restrictions, which is plausibly provided by the facts alleged in the complaint, or the implausible version asserted by plaintiffs, the conduct at issue falls squarely within the heartland of federal securities law and the regulatory authority of the SEC, which actively regulates electronic broker platforms, brokers, markets, clearing agencies. So again, this all goes back to the idea that they're saying that this is for the SEC to take care of. But in order for that argument to actually hold water, the SEC actually has to do something. Talking to you, Gary Gensler. So basically here they go through just an analysis as to why they believe the SEC, is the controlling body that should be overseeing this action. This is the end of their motion. Plaintiff's claim should be dismissed without prejudice. This part's a little bit interesting to me. Got to watch out for this part. So remember, there's two different. So in a court case, there's two different types of dismissals. There's dismissed with prejudice and dismissed without prejudice. So they're saying that plaintiff's claim should be dismissed with prejudice. That means that it should not be allowed to be brought again. Now, sometimes in a case like this, where the facts are really detailed, the court may deny the motion at least one time, only one time, without prejudice, which would give the applicant, the plaintiff, an opportunity to refile and restate their facts a little bit more clearly, especially if the judge believed that initially there might be something there, but they maybe just didn't plead it. They maybe missed it by that much. So if that's the case, then that would be without prejudice. They're asking for it to be done with prejudice. The defendant says, despite the additional time and discovery plaintiff had at their disposal, again, they're saying time like it takes a couple of hours to go through 25,000 pages. If the shoe was on the other foot, they'd be crying and lamenting about the fact that it took them so long to go through the discovery. Plaintiffs amended their consolidated complaint just days before the filing of this motion. Plaintiffs dared such attempt at pleading their claims, and they did so without defendant's written consent or leave of the court in violation of Rule 15 of the Federal Rules of Civil Procedure. The red line that plaintiff served on defendant prior to filing their amended complaint showed that plaintiff corrected the complaint to remove paramount allegations alleging their conspiracy claims against Robinhood. Such changes that were made are not simply technical corrections addressing punctuation or verb tense. These are substantive amendments pursuant to Rule 15 of the Federal Rules of Civil Procedure. Now, this is an interesting part because it seems like, based upon what they're saying, and it might be true because based upon what's uploaded in Pacer, it looks like that they did submit a new amended complaint on August 23rd, which is while the defendant was working on their motion to dismiss based upon an earlier version of the complaint. And if that's true, that doesn't mean the case should be dismissed with prejudice. It may lead the case to be dismissed without prejudice, because then it would give the defendant more time to address some of the arguments that maybe they missed. But they really didn't say that here. They're just asking for it to be dismissed with prejudice. So I don't think I don't think they feel that they didn't have enough time to review and add what they needed to do, and they might do it in the reply. So basically, I'm not sure about this part. I don't think it's really going to have any impact. That people amend their complaint, throughout the process. It just depends on how much new information they added. I know some of the bigger conversations between Citadel and Robinhood were added, on August 23rd as part of the amended complaint. So, and those are really the most important conversations in establishing the plausibility of the conspiracy. All right, guys. So this is a really long video. So this is the video on the motion to dismiss. I'm going to do a separate video on the opposition papers, just so it's not such a long video. I don't want to lose anybody. So all right. So basically, I will do a second video on the motion to dismiss. And until then, the lawyer of the apes is adjourned.